Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. We're going to talk about going through a divorce and the rights to your ex's pension or a part thereof. Do you have rights to it? And one might think, well, why should you have rights to it? On the one hand, yes, you've been married to the person. On the other hand, this is their pension from their work, all their life. Should you get half of it just because you happen to be married and now you're getting a divorce? And the answer is it's really not so simple. It's a sort of a complicated analysis of how it should go. First of all, when you talk about pension rights, we have to talk about getting the portion of the pension that is marital. The whole pension may not be marital in that the pension may not have been accumulated during the marriage. Some of it may have been before the marriage. So let's take an example. Well, take a couple of examples. If the parties get married in, let's say, 1990, and in 1991 you get a job and you're working with the UAW job, working in the factory, developing a pension. Now it's 2023, so it's many, many years later. You want to get a divorce, and the question is, what are we doing with the pension? In that scenario, the entirety of the pension was accumulated during the marriage. Therefore, the entirety of the pension is going to be in play as we discuss the division of marital assets. Odds are the court's going to find you're going to be entitled to have that pension. That's a fairly simple case. What if it's a little more complicated? What if the guy got the job in 2000? He got married in 2010. Now it's 2023. It's a 13-year marriage. Now there's a divorce. Is their pension right that goes and that is in play here with respect to the divorce? And the answer is yes, there is, and no, there isn't. There's a part there is and a part there isn't. The part that predated the marriage is off the table. We don't even look at that. We're only going to look at the pension benefit that existed from the time you got married in 2010 until the time of the filing of the divorce, 2023. We're going to look at 13 years of that pension, even though he may have contributed 23 years. The first 10 years are off the table. The next 13 are what we discussed. And of that 13, one would be entitled to half of it, that benefit. One would be entitled to the other half. So the person who's the pensioner is going to get half plus the 10 years. The one who's not the pensioner is going to get half of the marital portion. And that is how that scenario is going to work. Now, there is an exceptional scenario where the entire pension is really non-marital. But it's been a long-term marriage. And during that marriage, one of the parties, the non-pensioner, has become, let's say, disabled during the marriage, or has no means of support because of that. And it's a longer-term marriage. The court can look at the fairness of it and say, you know what? Yes, he got the whole pension, but it's not fair to have her impoverished when she's given her whole life to the marriage and now she's disabled for something. It's not a fault of her own. We need to give her something. So the court may, in that situation, either give her a part of the pension or work out an alimony situation so that she can be protected and include as part of that alimony the income that he'll get from the pension and other things to work that out. Now, every case is different. This is a particularly exceptional case. Obviously, it's going to be up to the court to determine what the outcome is in that fact-specific case. If you have one such case, reach out and we'll be glad to help you out.